Well, hello. You've been served a lawsuit, huh? Well, thanks for joining me today. I'm going to walk you through how to answer a lawsuit if you've been sued in Los Angeles Superior Court. Whether you're facing a contract dispute, a personal injury claim, an unemployment or employment lawsuit, or a probate matter, understanding the process can help you respond properly and protect your rights. Step one, you need to review the lawsuit. When you are served with a lawsuit, you'll receive a summons and complaint. The summons tells you that you're being sued, and the complaint lays out the claims against you. In Los Angeles Superior Court, you typically have 30 days from the day of service to file an answer. If you fail to respond within this time frame, the plaintiff may request a default judgment, which could mean you actually lose the case automatically. Step two, you need to make a decision on how you're going to respond. You generally have a few options when responding. File an answer. This is the most common response. You admit or deny each allegation and assert any legal defenses. 2. File a demurrer. This is a motion arguing that the lawsuit is legally defective, even if everything in the complaint were true. 3. File a motion to strike. This challenges improper or irrelevant parts of the complaint. 4. File a motion to quash. If you believe the court lacks jurisdiction over you, this motion can challenge service of process. 5. Negotiate a settlement. You can also try to resolve the dispute before formally responding. Step 3. You want to draft and file your answer. If you choose to file an answer, you'll need to prepare a Judicial Council Form, Answer PLDC-010, for general civil cases, or draft your own response following California rules of court. In your answer, you must address each allegation in the complaint by admitting, denying, or stating that you lack sufficient knowledge to respond. Affirmative defenses. Now, these are legal reasons why you should not be held liable. Examples include statute of limitations, fraud, or breach by the other party in a contract case. Then you want to sign and date the answer. Once your answer is complete, file it with the clerk of the court and serve a copy on the plaintiff or their attorney. In Los Angeles, e-filing is mandatory for most civil cases, so you'll need to file electronically unless you qualify for an exemption. Now, to do that, you use a service like One Legal in Los Angeles. There are others that compete, but One Legal is the one that pretty much everyone uses. Here are some examples of how this works in different case types. Contract law. Let's say you are sued for breach of contract. You might deny the allegations and assert defenses, such as the contract was void due to fraud. The plaintiff breached first. The statute of limitations has expired. Personal injury. If someone sues you for negligence after a car accident, you might argue you weren't at fault. The plaintiff was partially responsible. That's called comparative negligence. The injury was pre-existing. Employment law. If an ex-employee sues you for wrongful termination, your answer might include defenses like the termination was lawful and based on company policy. The employee was an at-will worker. There is no evidence of discrimination or retaliation. Probate law. If someone challenges a will, your response could be the will was validly executed. The plaintiff lacks standing. The deceased had full mental capacity when creating the will. Now, the cost involved in filing an answer in Los Angeles Superior Court comes with a fee. As of 2024, the filing fee is $225 to $435 for general civil cases, depending on the amount in controversy. Fee waivers are available for those who qualify based on income. So what happens next? After you file your answer, the court may set a case management conference, CMC, where both sides discuss the case's progress. Discovery meaning both sides exchange evidence, take depositions, and request documents. You want to avoid discovery because it can get very expensive. So the best thing to try and do, if you have to play hardball, make it look like you're going to fight, but somewhere in there, try and settle. You may have motion hearings where either side can ask the court to dismiss claims, compel discovery, or take other actions. If the case isn't settled, it proceeds to trial, which could take months or even years. By responding properly, you keep your options open, whether that's negotiating a settlement or fighting the case in court. If you're unsure, consulting an attorney can help ensure you don't miss critical defenses or procedural steps. Or you can email me and see if we can work together. I would be basically your assistant, as you would be the attorney, so to speak, in your case, representing yourself in pro per. Now, some notable verdicts in various areas of law. Understanding the potential outcomes of litigation can be insightful. Here are some notable verdicts across different areas of law. Contract law. In the early 1970s, the U.S. financial litigation resulted in a $50 million recovery for the purchasers of securities from a failed real estate development company. This case was one of the earliest large class actions, highlighting the significant financial implications of contract disputes. Personal injury law. In 1999, a Los Angeles County jury awarded $4.8 billion in punitive damages against General Motors to a group of 6 burn victims whose 1979 Chevrolet Malibu was rear-ended by a drunk driver, causing it to catch fire. This verdict was later reduced to $1.2 billion by the judge, but remains one of the largest personal injury awards in history. Employment law. In 2014, a former AutoZone employee was awarded $185 million in punitive damages in a pregnancy discrimination case. The jury found that the company had demoted and later fired the employee after she became pregnant, leading to one of the largest employment discrimination verdicts ever on record. Probate law. While large verdicts in probate law are less common, disputes will result in significant financial implications. For example, in cases where wills are contested, courts have awarded substantial sums to rightful heirs when fraud or undue influence has been proven. I hope this information helps you understand the process of answering a lawsuit in the Los Angeles Superior Court, and you should be able to apply it to courts all over the country. You'll just have to get familiar with your own court rules. I hope this provides insight into potential outcomes in various areas of law. If you have any questions or need further assistance, don't hesitate to seek legal guidance or paralegal guidance from me right at the email on top here. Thank you for listening.